Today we're going to look at safety legislation in Western Australian mining. We'll look at the current Mine Safety and Inspection Act and regulations, its history, influences, and the origins of occupational health and safety general. While ancient history records practices that are now regarded as barbaric, such as slavery and torture, both the Egyptians and the Romans introduced health and safety at the public level. Of the several law codes surviving from the ancient Middle East, one of the most famous was written by Hammurabi, a king in Babylon, or ancient Egypt, around 1700 BC. The Code of Hammurabi was engraved on a black stone pillar and contained over 3,600 lines of engraving. Most of the laws and rules in the code are centred on the primitive justice system based on retribution and the eye for an eye principle. However, in its concern for widows, orphans, and injured or helpless people, the code contains the first manifestations of the principle of workers' compensation. Hammurabi's legacy was passed on to the ancient Greeks and Romans, whose legal systems would form the foundations of our modern legal system. During the Middle Ages, particularly the 1500s through 1700s, there was an emergence of publications on the health effects of work. These publications included Agricola's De Re Metallica, published in 1556, which identified dust diseases in the lungs of miners and emphasised the need for ventilation in mines. Paracelsus's 1567 work detailed the diseases of miners and smelter workers, and in 1700, Ramazzini was the first physician to systematically examine the effects of work on human health. His book, Disease of Workers, still has relevance today. Perhaps the greatest influence on modern safety law was the Industrial Revolution. As industrialisation swept across Europe from about 1750 to 1830, the way in which work was performed changed dramatically. There were new industries, new processes, new forms of power, and new economic and social conditions. These changes led to industrial injury and disease on a scale that had never been seen before, which in turn led to greater attention focused on the health and safety of workers. The introduction of new power sources and machines increased risks and introduced new hazards that had not been previously seen. Child labour was common. Workers worked in appalling conditions for meagre pay. Workplace hazards were just considered part of the job. Following an outbreak of fever among children working in the cotton mills in Manchester, demands for better working conditions were made. These and other factors led to the Health and Morals of Apprentices Act of 1802. This act is considered a milestone because it marked the beginning of government involvement in workplace health and safety. The Act regulated factory conditions in regard to pauper children who worked in cotton mills and woolen mills. These children were basically slaves, working for up to 16 hours per day, 7 days per week, in appalling conditions. Under the Act, the working hours of children were limited to 12 hours per day. Separate accommodation for boys and girls had to be provided, and rudimentary working conditions were introduced. For example, factory walls had to be washed with lime twice a year, and windows were required for ventilation. The 1802 Act was replaced in 1819 by the Cotton Mills and Factories Act, which applied to both free and pauper children. Under this Act, no children under 9 years of age were allowed to work, and children who were aged between 9 and 16 years were limited to 12 hours work per day. Again, the focus was on the employment of children. In 1833, the Factory Act came into force, mostly as a result of social and economic unrest and the pressure for shorter working hours, including the worker-led 10 hours movement. This Act extended the provisions of the previous acts, including restricting the working hours for 9 to 13-year-olds to 9 hours per day and banning children under 18 from working at night, or more specifically between 8:30 p.m. and 5:30 a.m. An inspectorate was also introduced to enforce the new law. Inspectors had broad powers, similar to the powers of mines inspectors today. In 1838, a serious mining accident at the Husker Colliery, which resulted in the death of 26 children, 11 girls aged 8 to 16, and 15 boys aged between 9 and 12 years old, prompted Queen Victoria to call an inquiry looking at the employment of women and children in mines. Victorian society was shocked to discover that children as young as 5 or 6 worked as trappers, opening and shutting ventilation doors down the mine before becoming hurriers pushing coal tubs. Despite the outrage, there was a fair amount of resistance to the passing of mining safety laws, especially from the mine owners. However, the head of the inquiry, Lord Ashley, appealed to Victorian prudery, making note of the fact that girls and women wearing trousers and working bare-breasted in the presence of boys and men, which made girls unsuitable for marriage and unfit to be mothers. The Victorian morality ensured the bill was passed, and the first Mine Regulations Act was enacted in Britain in 1842. This act included provisions to ban mine owners employing women and boys under 10 years of age to work underground. Importantly for us, this act marks the beginning of the legislative approach to workplace health and safety in mines. One of the key factors in the emergence of the general principle of liability for negligent conduct came about as the result of a bizarre product liability case. Donoghue versus Stevenson, known as the Paisley Snail case, began in a cafe in Paisley, Scotland in 1929 and concerned itself with a situation where a bottle of ginger beer was brought in the cafe by Miss Donoghue's friends. Ginger beer at the time was bottled in dark brown bottles, and Miss Donoghue had already drunk half a glass before a decomposed snail made its appearance. With the horrified realisation that she had inadvertently been drinking decomposing snail juice, Ms. Donoghue suffered distress, revulsion, shock, and eventually severe gastroenteritis. While an apparently trivial issue, the case opened up the possibility of workers suing manufacturers for defects in materials, equipment, and plant that caused injury. The case focused on the duty of the ginger beer manufacturer to provide a system of work that would not allow snails to get into his ginger beer bottles, and the duty to provide an effective system of inspecting the bottles before they were filled. Ms. Donoghue won the case because it was found he, the manufacturer, had failed in both of these duties and therefore caused the incident. Ultimately, the case was appealed in the UK House of Lords. In his 1932 judgment, Lord Atkins resonates: "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour." These carefully chosen words establish the principle that people who have been hurt through the negligence of others have the right to be compensated. This is now better known as duty of care. By the early 1970s, it was becoming apparent that safety legislation was becoming ineffective. There were a number of factors at play. It was recognised legislation had become a blunt tool using prescription for controlling workplaces, and there was a need for employers to understand, accept, and control workplace risks. Legislation was also not keeping up with the emergence of new technologies. It was also recognised there was a need for OSH in all workplaces. In the UK, the Robins Royal Commission was established to look at these issues. In 1972, the report of the Robins Committee on Safety and Health at Work was presented to the UK Parliament, and it revolutionised the control of health and safety in the workplace. The Robins report recommended the development of generic, performance-based OSH legislation to establish in law the employer's duty of care through a system of communication, training, and self-regulation. The report suggested there should be general duties clauses which were sufficiently broad to cover virtually every conceivable risk in the workplace. Robins also recognised that general OSH acts or laws would be insufficient with regard to all OSH activities, and suggested that the main acts would need to be supported by other legislation, codes and standards. We can see this today where the Mine Safety and Inspection Act is the overarching act that sets out the general duties of care for employers and employees, and is supported by the Mine Safety and Inspection regulations and various Australian standards and codes of practice, which detail recommendations and controls in respect to specific hazards. The first mining safety law in WA was introduced in 1895. The Mine Regulation Act 1995 was strongly influenced by the British laws of the time, to the point that it almost mirrored the UK Act. It was also influenced by a series of major mining accidents such as the Bully coal mine disaster in New South Wales that killed 81 men and boys in 1887, and the new Australasian mine disaster in Creswick, Victoria that killed 22 men in 1882. The Act included very little general provision for controlling hazards, and was instead highly prescriptive with piecemeal regulation for specific hazards. The Act did establish an inspectorate and also incorporated regulations for collieries. By 1946 there had been a number of amendments made to the Act. These amendments were consolidated in a new Act also titled the Mine Regulation Act. The structure and content of the new Act were almost identical to the 1895 version, and the regulations were again prescriptive and limited. The most noticeable differences were the introduction of classes for inspectors. These were district inspectors, workers inspector, and special inspectors, the same classes of inspectors we see today. Also by 1946 we see the introduction of regulations around working hours, consecutive days worked, and work on Sundays, mostly as a result of pressure from the unions to improve working conditions for miners. In 1984, the Occupational Health and Safety Act was introduced into WA. The OSH Act was heavily influenced by Robins, and there was debate on the scrapping of the mines regulations and pursuing a single set of OSH laws for Western Australia. It was decided to keep the jurisdictions separate, and the 1946 Mines Regulation Act stayed in place, and it would be a further 10 years before mining saw legislation that began to move towards the Robins model. These changes came in 1994 when the Mine Safety and Inspection Act was passed. This Act, which is our current Act, has as its core duty of care and development of safe systems of work to identify and control hazards. The Act outlines the general duty of care of employers, including an employer must provide and maintain a working environment where employees are not exposed to hazards. Employers must provide and maintain safe workplaces, plant and systems of work. They must also provide information, instruction and training to and supervision of employees so that they are not exposed to hazards. Employers must consult and cooperate with safety and health representatives and other employees at the mine regarding occupational health and safety, When the employer cannot remove a hazard, they must provide PPE to employees. Interestingly, this is at no cost to the employees. However, the duties are not one-sided. The Act also imposes duties on employees. As employees at a mine, we must all take reasonable care to ensure our own safety and health at work and to avoid adversely affecting the health or safety of any other person by anything we do or don't do. So what does duty of care mean to you?
Duty care is when you take care of yourself and all your other workmates in and around your site.
Look after yourself and look after all the people around you. That's the responsibility of your employers to look after your workers and the workers to look after each other.
Duty care is everything that you do to keep yourself safe and look out for others to make sure they're doing something safe, and yeah, just pretty much that. Do what you can and look out for others.
Duty of care is the responsibility for yourself and for others.
Duty of care, making sure yourself and other employees around the area are safe in the workplace.
Duty of care is your responsibility under the Mines Inspection Act to look out for your fellow worker and as well as yourself.
Duty of care, that would be looking out for the welfare of yourself first and your workmates and your company and your area around you.
Duty of care, looking after yourself and others, not doing anything that's unsafe.
Looking after yourself and others around you.
Duty of care is looking after your mates. I quite like the people that I work with and I want to see them go home all right.
Duty of care is to look after yourself and your workmates.
Taking care of myself and my fellow worker, making sure I'm safe and my fellow workers are safe.
Making sure I do things correctly so I don't hurt nobody else or myself.
Responsibility, watching out for others that you work with, just making sure you're safe.
Ensure I don't endanger anyone else on the site by what I do.
Your duty to, for safety, for your own welfare and the safety of others at a mine site in your working environment.
It's looking after yourself and others, so you go home at the end of the day and you go home the same way you come to work.